Thank you. Mr. Raskin?
Thank you kindly, Mr. Chairman. And I was glad that my colleague, Mr. Goldman from New York, was able to answer some of the surprising things that we heard from our esteemed colleague, Ms. Mace, right before we had our break. It's very clear that Joe Biden is, that there's no evidence that has turned up over the last 7 months that Joe Biden is guilty of any criminal wrongdoing, any high crime and misdemeanor, much less prostitution, bribery, money laundering, or any of the crimes that were set forth in that laundry list that Ms. Mace offered at the end. So I do hope she will clarify that. Let's see, Ms. Wayne, you're here as the Assistant General Counsel of Johnson & Johnson. Do I have that right?
Yes, sir.
And Johnson & Johnson paid $5 billion out in the opioid litigation and $4 billion in the talcum powder litigation. Is that right? Those numbers roughly correct?
Congressman, as far as I'm aware.
Okay. So are you here to complain about meritorious lawsuits being brought by consumers in cases like these, or frivolous and meritless cases being brought by consumers?
Congressman, an excellent point. We're not here to talk about limiting aggrieved consumers' access to justice. We're here to talk about transparency, regulation, disclosure around third-party litigation funding, which has an effect of actually diluting the claims that have merit with the influx of meritless lawsuits.
Okay, so you have no problem with the litigants who went to court in the opioid cases or in other mass toxic tort cases, the BP oil spill or the talcum powder case or so on?
Congressman, as a lawyer, I believe in access to justice.
Gotcha. And there were no Rule 11 sanctions that your company sought against any of the litigants in those cases, right?
The ones that you mentioned, Congressman?
Yes.
Not as far as I'm aware. In the mass tort context, it's actually extremely different. Because we have no access to information regarding the thousands of claims brought against us, because plaintiffs aren't required to actually produce evidence of product usage or injury alleged from the product, we're essentially hamstrung from using Rule 11 to bring sanctions on those individual cases. We're also hamstrung in many cases from filing 12b6 motions, because that motion practice is usually suspended in the MDL process.
So you're saying you can't move to dismiss in a class action lawsuit?
Not a class action, Congressman, right? We're talking about multi-district litigation, which is a different animal.
Yeah.
Multi-district litigation, the aggregation of thousands of claims. Typically what we see are judges suspending motion practice, 12B, 12E, the usual discovery practices.
Yeah. Okay, well, that might be something interesting to look at, but to my understanding, anybody who brings vexatious, frivolous, or meritless litigation can be sanctioned by the courts. But I appreciate your candor in saying that that was not the case in the opioid litigation or in the talcum powder case.
What I said, Congressman, is that we believe in access to justice. So
yeah.
Those who brought those cases had their day in court. We don't stand in the way of that, of course.
Right.
And as I mentioned earlier, we don't believe that the talcum powder cases have merit. We believe that that is actually all driven by third-party litigation funding.
All right, fair enough. Well, maybe we should stop there because we're just going to disagree about that. And obviously, the settlement speaks for itself. One of our colleagues, actually several of our colleagues raised this issue, but one of them asked whether the Chinese government might have used intellectual property law or lawyers to achieve power over the U.S. government and to undermine American society. And I think I found at least one good answer to this question, and I'd like to submit for the record this November 6, 2018 Associated Press article headlined, "China Grants 18 Trademarks in 2 Months to Donald Trump and Daughter." In the early days of the Trump administration, Donald Trump and his daughter Ivanka got 18 trademarks from the Chinese government that she had been unable to get before, and there were lots of allegations about conflict of interest and influence peddling in the scheme. So I'd like to submit that for the record, Mr. Chairman.
Very good.
Very good.
Yeah, I yield back. Thank you.
Thank you. Mr. Gosar.